We will now hear oral evidence. Point of order.
I'd like to make a point of order regarding the instruction that's been laid by the government that will be heard on the floor of the House on Monday regarding expanding the elections bill to include electoral voting systems, specifically in return to mayoralties within England and police and crime commissioners. I just wondered if it would be in order, Chair, for the committee to ask questions of Dr Renwick about electoral systems, given that, as would be my understanding, Chair, they wouldn't currently be in the scope of the bill?
Yeah, thank you for the point of order. My understanding is that currently it's not in the scope of the bill. I'm aware it's on the order paper for Monday, and that's my understanding.
Can I further that point of order, Chair? Is it possible for the committee to take evidence on electoral systems at any future scheduled evidence sessions that would perhaps take place after Monday, when it would, of course, become presumably part of the bill?
It is possible to have a supplementary programme motion that it could be added in, but that's not a matter for me. That's usually done through usual channels.
Thank you, Chair.
Okay. So I welcome Dr. Alan Renwick, Deputy Director of the Constitution Unit, University College London. Thank you very much for joining us. For this session, we have up until 4:30. Would you please introduce yourself for the matter of record, please?
Thank you, Chair. I'm Alan Renwick, as you said, from the Constitution Unit at University College London, and I lead our work on elections, referendums, and some of our recent work also on the structure and functioning of the Union.
Thank you very much. Kat Smith, would you like to come in?
Thank you, Chair. Dr Renwick, thank you so much for your time this afternoon. If I could begin by asking you a little bit about the Electoral Commission. Obviously, this legislation proposes some changes to the way the Electoral Commission is managed in terms of government setting out a strategic document to direct the work of the Commission, but also slight changes to the Speaker's Committee on the Electoral Commission by adding in a new government minister to a committee that already has a government bias on it. I just wondered if you had any examples of how electoral commissions work in other democracies, and what level of government interference is there over regulators?
Well, the principle for a good electoral commission is that it should be independent from government. The details of how that works in different countries around the world depends a great deal actually on kind of political culture. It's not just a matter of institutions. So I wouldn't attempt to draw very tight parallels from how things work in other countries to how things should work in this country. For example, some countries might have a procedure through which members of the Electoral Commission are appointed through quite a process that looks quite political on the surface, but in fact, in practice, given the conventions in a particular country, is properly neutral and does protect independence. So I think the key thing for us to be thinking about is how do we ensure the independence of the Electoral Commission alongside the appropriate accountability of the Electoral Commission in the particular UK context. And I'm afraid it seems to me that the proposals that are in the bill in this regard are wholly contrary to the principle of independence of the Electoral Commission. I said independence and accountability both matter, and it's absolutely right that there should be parliamentary accountability. There is already a great deal of parliamentary accountability of the Electoral Commission. It is, of course, accountable to the Speaker's Committee. PACAC, the Public Administration Committee, scrutinises the work of the Electoral Commission a great deal. And there is also accountability to the Scottish Parliament and to the Senate. So I don't think there's a deficit of accountability of the Electoral Commission at present. But on the independence side, I think independence requires quite simply that Parliament lay down the remit of the Electoral Commission, and that must happen through primary legislation, so that Parliament can properly scrutinise and amend the remit of the Electoral Commission. And it's not simply a matter that is written in government and subject to much more limited parliamentary scrutiny or opportunity for amendment. So Parliament should lay down the remit for the Electoral Commission, and then the Electoral Commission should get on with doing that, delivering on that, subject to appropriate scrutiny as already exists. The idea of having an additional strategy and policy statement that is written by ministers without, as I said, the appropriate degree of scrutiny just flies in the face of the principle of independence and therefore seems to be wholly inappropriate.
Thank you, Dr. Renwick. And you said in your answer there that the Electoral Commission is also accountable to the Welsh Senedd and the Scottish Parliament. It's also funded by both these parliaments as well. And I just wondered if you, what consideration you thought we should be giving as a committee to the change that a strategy and policy statement would be given by a UK Parliament, and what tensions that potentially creates within the Union.
Well, it creates potentially very great tensions. So clearly, this is a proposal that would require a legislative consent motion if it's going to be compatible with the Sewell Convention. The Senedd, or rather the Minister in the Welsh Government, the Counsel General, has already indicated that he does not recommend that a legislative consent motion be passed on this matter, and I presume the Scottish Parliament will do the same. So what this part of the bill envisages is that ministers in the UK government, subject to Parliament, to affirmative procedure, would be able to specify guidelines for devolved matters, and Scottish and Welsh ministers would only be consulted and indeed would only potentially be notified in the case of amendments to the statement. And that just seems to me wholly contrary to the principles of devolution that have been established. And I can't see any justification for it. And the Sewell Convention indicates that Westminster will normally not legislate in matters that have been devolved. There is nothing abnormal here. There is nothing unusual. Nothing has changed since these matters were devolved to Scotland and Wales. These devolution changes didn't take place very long ago. So it seems to me very, very problematic. And it also heightens an issue that already exists with the governance of the Electoral Commission. That the members of the Electoral Commission, the commissioners themselves, are appointed all on the recommendation of the House of Commons, and that on the recommendation of the Speaker's Committee. And the Speaker's Committee has, in recent appointments of commissioners with responsibility for Scotland and Wales, either consulted the presiding officer or the Llywedd, or included a representative of those people in the committee responsible for shortlisting. But that has been entirely at its discretion. And it seems to me that there is a need for reviewing the arrangements for governance of the Electoral Commission in light of the recent devolutions of electoral matters in those areas. There was last a serious review of this matter conducted by the Committee on Standards in Public Life in 2007. And at that time it said that the current governance arrangements were appropriate because these matters were not devolved. Well, clearly these matters have been devolved now, and therefore I think that there is a need for a review. My impression is that it's a point that hasn't really been thought about terribly much. I don't detect that the Scottish Government or the Welsh Government has done much detailed thinking on this, but I think some consideration is needed to how it can be ensured that the Scottish Parliament and the Senedd are properly represented in these processes. And just one final point that I should make in this area, and it's a point that has been made by some other people, but the fact that at present the Speaker's Committee has a majority from a single party, again, simply is indefensible against the principle of independence of electoral processes. And I think it is essential now. I mean, it has never happened before. It didn't happen when there were large majorities for governments in the early 2000s. At that time, there was no majority for that party in the Speaker's Committee. It has been allowed to happen now, which suggests that the sort of conventional constraints of improper exercise of power, to be honest, are not working. So I think legislative action is needed to ensure that there is never a single party majority on the Speaker's Committee.
Thank you, Dr. Renwick.
Minister?
Thank you very much indeed, and thank you very much for joining us, Alan, Dr. Renwick. It's very good to have you and have your expertise. I wonder if we could make use of that expertise actually with a sort of relatively simple starting point, and it's Clause 14, membership of the Speaker's Committee. I think every so often we hear a misrepresentation, and I think I just heard the lady from the opposition doing this in suggesting that there's going to be an extra Minister of the Crown added to the Speaker's Committee. Could you just help us confirm, Dr. Renwick, that concurrent powers, which is what is in Clause 14, which, as you'll remember, comes in the history also of having made a transfer of functions order before, that actually this is a question of a substitute minister, effectively a junior when the senior is too busy?
I'm not a lawyer, so I did wonder when I looked at those words exactly what they meant. But if they mean what you have described them as meaning, then they don't trouble me. And it was always the intent of the PIPERA legislation as passed in 2000 that the minister was responsible for elections, responsibility for elections, and the minister with responsibility for local government should be members of the Speaker's Committee. And if the change is simply intended to ensure that the minister who does have responsibility for elections can participate, but there are only two ministers who are participating, then that change does not seem to be problematic.
Thank you. That's really helpful just to get that on the record. Can I also just go on to your points about backbench members of the... Actually, forgive me, let's start with all members of the Speaker's Committee, because, of course, it's worth just noting that, as well as ministers, there are shadow ministers. So there is already, if you like, front bench involvement on both sides on that committee, which I think is helpful to understand. But going to the backbench members of it, could you confirm that it's the case under existing law, which is not changed by this bill, that the Speaker may appoint the 5 backbench members of the committee? That is his power to do.
Yes, that is absolutely correct. And I mean, I don't know what went wrong in this case. It seems to me, I cannot see an argument against the view that something has gone wrong in the current composition of the Speaker's Committee, and it is wrong that it has its current composition. If you look at the 2007 Committee on Standards of Public Life report, then it points out that, and indeed there is a quotation from evidence provided by the Speaker's Committee at that time, saying that the convention has been applied, that the Speaker's appointments will be made such that there is no single party majority. So that convention was understood in 2007. The CSPL at that time recommended that it should be formalised. That hasn't taken place, and somehow things went awry at the start of the present Parliament, and I don't know what happened, what went wrong, but I think given that it has gone wrong, legislative change is now needed to ensure that it not go wrong again.
How would you change what is therefore extant in legislation that the Speaker would have the ability to appoint 5 backbench members?
Well, I would suggest that there is simply a stipulation that power be exercised subject to the constraint that there shall never be a majority for MPs from any one party within the membership of the committee.
Okay, well, thank you. That's given us some food for thought and a very helpful historical recap as well. Thanks for that. May I go on to your points about the Sewell Convention? Which were interesting, and I just wanted to have your written evidence in front of us, as well as what you've just said earlier, a moment ago. In your written evidence, you say the proposed strategy and policy statement violates the Sewell Convention. Your words just now, I think, were accurate in saying that the Sewell Convention says that this House will not legislate normally for affairs that are devolved without consent. So you've just clarified in your words here with us today that it is the existence or otherwise of an LCM that would violate the Sewell Convention. Could you just, for absolute clarity, confirm, therefore, that the strategy and policy statement does not in its own right violate the Sewell Convention, but the behaviour and procedure around it is where you direct those comments?
I intentionally changed my comments because what I wrote in my written evidence was somewhat inaccurate. So what I should have said was that if there is no legislative consent motion on this aspect of the bill, then the inclusion of the strategy and policy statement as currently set out would violate the Sewell Convention.
Again, thank you. That's helpful and clear.
I mean, it seems very likely that there will not be a legislative consent motion. That was the presumption that I was making, but I realised that was a presumption that I should not have been making without clarification.
Well, thank you. It's really helpful to have been able to do that today. And again, I'm sure you would also be able to say from your experience monitoring many of these kind of bills and exchanges that it can take a little time for that position to emerge in terms of what the intention is of the executive in any one of those legislatures and then the intention of the legislature. It takes some time. There isn't necessarily a moment yet in this bill where you could have made a statement that said this violates the Sewell Convention.
Yes, absolutely. And the Welsh Minister in his legislative consent memorandum indicates that he is in conversation with you, which I'm very glad to hear. And I hope that you would take your normal constructive approach in seeking a solution to this issue.
Exactly that. That's good to have clear. And then my final question, if I may, just goes to the strategy and policy statement and its procedure in Parliament. And just now, you gave the view that it would be wrong for the government to produce that statement. And then I think I'm quoting you said, without the appropriate degree of scrutiny. Would you be able to explain what you think is not appropriate about the statement being approved by both Houses of Parliament?
Well, it would be subject to much less scrutiny than with primary legislation, and it would not be amendable. So I think so far as possible in this area, the principle should be applied that the rules are made in a reasonably consensual cross-party manner. I realise that's very difficult and it is not guaranteed by the primary legislative process, but at least there is a process for proper scrutiny and discussion of those proposals in a cross-party forum. And the procedures around the strategy and policy statement that are indicated in the bill just don't enable that degree of scrutiny, which I think is simply not appropriate.
But Parliament, in the form of the entire chamber twice, does provide for debate, as you were just saying.
Well, there isn't the kind of detailed scrutiny that we're having today, for example, in which there's an opportunity for detailed discussion of those proposals to take place. And also, of course, so part of what we're doing here today is bringing in the views of a variety of people from beyond Parliament as well. And it is essential that the processes of accountability for the Electoral Commission should be both cross-party and non-party. Those two features are essential for ensuring that electoral integrity is maintained, for the simple reason that, as a member of the committee alluded to earlier this afternoon, however wonderful MPs are, and I have great respect for MPs, and I know some of you on the committee, and I think you're great people, genuinely, but you have a vested interest in these issues. We're talking about a body that regulates some of the activities of MPs. And in that context, it is essential to ensure that there's a process that brings in voices from outside Parliament And the primary legislative process just allows that to a much greater degree than does a simple affirmative resolution.
Okay, well, thank you for that perspective. That's very helpful. So essentially, you'd be arguing that this measure ought to be subject to the full primary procedure. Can I just ask one last clarifying question? Then I will, as it were, get the executive to shut up and give over to the backbenchers, which is, I'm sure, a principle you'd agree with, Alan. Could you just confirm that the bill's measures leave in place, don't affect, take nothing away from, the governance structure and statutory provisions for the Electoral Commission's board and commissioners, which include party figures, cross-party figures and non-party figures, as you were just desiring?
Yes, absolutely. So the changes introduced in 2009 with the introduction of party members of the Electoral Commission were a desirable step in ensuring that all voices are properly represented in the governance of the Electoral Commission, and those are not changed. I mean, I think, as I've indicated, in some respects, those governance structures need to be changed. So particularly regarding the composition of the Speakers' Committee, and also the question of how we reflect the devolved arrangements. But yes, I agree that those particular arrangements that you mentioned are not changed.
Thank you so much, Alan. It's good to debate with you as always, and really good to have your expertise.
Thank you, Minister. Brendan O'Hara.
Thank you, Chair. Thank you, Dr. Renwick. My first question would be, we've spoken to a number of witnesses over the last couple of days around this policy, this strategy policy statement, including a former Electoral Commissioner, and no one seems to have been aware that this was coming. Could you tell me, were you aware of this proposal being trailed or discussed privately with either the devolved administrations or in academic circles to see if these changes would enhance and improve the independence and the working of the Electoral Commission?
No, I was not. I wouldn't expect to have been aware of necessarily all of the consultations that might have taken place, but I don't recall being aware of these proposals before they were announced by the Minister in June. And I do think that is problematic, to be honest. So I've expressed concerns about the substance of these proposals. But I do think procedurally there is a difficulty here as well, because of the point that I have already alluded to, that with the best will in the world, and with full respect to you as MPs, the fact that you have a vested interest in this issue does mean that I think it's incumbent upon you to proceed with particular care when you're thinking about electoral matters generally, and particularly the governance of the Electoral Commission. And I think the procedure that ought to be followed in such a case is that there is an independent review before any recommendations such as those that have been introduced here are put forward. That was the case in 2000. The introduction of the Electoral Commission in 2000 stemmed from if I remember correctly, the 5th report of the Committee on Standards of the Public Life. The changes in 2009, introducing, among other things, the partisan commissioners, reflected recommendations made in, if I remember, the 11th report of the Committee on Standards of the Public Life. But there's been no comparable process in this case, and I just don't think that's an appropriate way to introduce significant changes in the governance of the Electoral Commission.
And can I ask you then, probably to speculate, why do you think it has not been done as you would have expected it to be done and has been done in the past? Why do you think it's been done this way?
I don't think it's for me to speculate on that, to be honest. I regret that it has happened in this way. I have great respect for the Minister, and I hope that there may be scope for reconsideration of some of these aspects. And for example, as you all will be aware, the CSPL did publish a report just 2 days after this bill was published on the regulation of election finance, which of course is part of what the bill covers. And I would very much hope that the government has been considering the recommendations made in that report and might be introducing amendments to take account of many of those recommendations. I thought it was an excellent report. So I hope there is scope to do things, to change the elements of the bill in order to reflect the views that have been heard since its publication. Because I do think the steps up to that point were too hasty.
Okay. And my final question would be that throughout this evidence session, a recurring theme that we've heard is about increasing public trust in electoral systems and the institutions that support them. Do you think that this proposal from the government will increase or decrease the public trust in the independence of the Electoral Commission?
I guess I would say that the main point is that the governance of the Electoral Commission should stand up to proper scrutiny and should be appropriately independent. Frankly, whether it has much impact upon public perceptions, I'm not sure. I suspect most people have other higher priorities in mind. But I think certainly these measures diminish the integrity of the electoral process, or they will do if they're introduced. And that ought to be regretted. Quite what effect that has upon public opinion as such, who knows? Who knows?
Okay. Thank you.
Thank you. If there are no further questions from members, can I thank Dr. Renwick for your evidence this afternoon? Much appreciated. Thank you.
Thank you.
The committee will next meet at 9:25 a.m. on Wednesday, the 22nd of September, to begin clause-by-clause consideration of the bill. I invite the Government Whip to move the adjournment.
I beg to move that further consideration of the bill be now adjourned.
The question is that further consideration of the bill be now adjourned. As many as are of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. The ayes have it. Please could people leave the room promptly while observing social distancing. Order, order.